Hey guys, we've been talking about the Darrell Brooks case, his appeal, and how it's unlikely his appeal will be successful, which is certainly something I agree with, as over 90% of criminal appeals in Wisconsin are not successful. But there's another percentage that is successful, and let's look at how that can happen. Because when the law gets weird, so do the cases. And we'll stay in Wisconsin and we'll just head over to Kenosha for a very bizarre case. So let me set the stage for you as a reasonable person, not tainted by the ridiculous theories that lawyers come up with when they're in their offices, and put this hypothetical to you. Let's say my wife and I are not getting along, and she's afraid that I'm going to kill her, and she's finding things that support that belief that I'm going to poison her to death. She tells a flaky neighbor down the street, I'm worried, I'm finding things, syringes, my husband's trying to get me to drink weird things. I'm not suicidal. If something happens to me, he needs to be checked into. I'm afraid of this. Tell that to a flaky neighbor. And then I tell it to a police officer, right? Actually call a police officer and say those same things. So the same statement to a police officer and to a flaky neighbor down the street. And and I do end up killing her, right? And they charge me and they want to bring this evidence in. Well, I'm like, no, I don't like evidence that's bad for me, Your Honor, so I object. Plus, she's not here to testify, so which evidence can come in? The statement to the flaky neighbor, the statement to the sworn police officer, both or neither? And the answer is, while this seems ridiculous, the flaky neighbor likely would be the one that could come in and not the police officer. So if you tell the police officer these things that are making you frightened and you're worried you're going to be killed and this is the person and all that, that's not coming in. But if you told your flaky neighbor that, then that probably could come in, subject to some hearsay rules. What? That doesn't make any sense, right? Just as a matter of common sense, if you can trust a flaky neighbor to recount someone else's secondhand statement, why can't you trust the police officer to do the same thing? And it being more especially serious that the wife would go tell the police officer these things rather than just gossip down the street. So it seems backwards, but there's a reason for it. But it goes down a rabbit hole that our Supreme Court has contributed to that caused a murder case in Wisconsin where the guy killed his wife in 1998 to being convicted, to being in the appeals courts for decades. And now it's on court TV as he's being tried again, all over this kind of issue. So let's go over what's at stake in this case and why it's been on appeals for so long. So Jensen is a guy, Mark Jensen, is someone who was convicted for killing his wife. And at least according to the medical people involved, he poisoned her with antifreeze, maybe gave her some other drugs to sedate her, and then also suffocated her because she had shown an unwillingness to drink a lot of this wine that he was wanting her to drink. And she had become suspicious because of the breakdown in their relationship. She started finding syringes. She started finding his web searches and web pages about poisoning and notes that were similar to that, and the weird changes in his behavior, like following her around with a particular glass of wine, saying, you got to drink this, and putting it next to her, begging her to drink it. So she became suspicious he was going to take her out. And he had made comments to other coworkers about taking it. There's a lot of evidence against the guy, not just what the wife said after she died. Anyway, so she dies, and it comes out that she told a teacher, a doctor, a neighbor, and a police officer these concerns that she had. She also wrote a letter, gave it to the neighbor, and said, in the event I go down, because I'm not suicidal, give this letter to the police. Right? And so that's the letter from beyond the grave that was a big issue in this case, that was made a big issue in the first trial, but it won't be allowed in the second trial. So what is all this about? So the Sixth Amendment, which has a lot of interesting things in it, subject to a lot of appeals and protections for criminal defendants, includes a part of it that says you are entitled to be confronted by the witnesses against you. So not a star chamber thing where secret allegations are made and you have no ability to confront those things. And basically what that means is you can't use allegations against someone out of court as a general rule. They need to come into court and make those and be subjected to cross-examination in front of the jury so that the jury can weigh everyone's credibility and the person has a chance to defend themselves. That seems fair, right? A broad exception to that is if the person is unavailable, maybe they're dead or whatever, and the other person had a chance to confront them, cross-examine them. So sometimes you might see testimony from a prior trial introduced in a case, and that's okay because the person, say, died after that as a witness, but the defendant had a chance to cross-examine them in the trial on the same kind of stuff. So sometimes that does come in. I think some of that's even in this Mark Jensen case. Well, anyway, Julie Jensen, she's not available to come to court and testify about her murder because she's been murdered, right? So she can't come there. But also, obviously, there was no chance for the husband to cross-examine her because he murdered her before she was ever going to be cross-examined. You're starting to see an issue with this, I think, maybe, probably. So anyway, under the Sixth Amendment, that's a problem. So the Supreme Court has kind of divided that in the first realm of what? How many angels can dance on the head of a pin kind of thinking and stuff like that. And the Supreme Court has said this Sixth Amendment protection applies to testimonial comments, not non-testimonial comments. So in this hypothetical I gave you before where the police officer couldn't testify but the flaky neighbor could, it can be viewed as a judge like this, that a statement to a police officer, knowing that's a law enforcement official, making that kind of statement, the person understands, the potential victim, that this could be used in an investigation and a proceeding against the other person. So it's testimonial. It's a witness against that person. Whereas if you're just talking to your neighbor, you wouldn't necessarily think, well, this is going to be evidence against my husband if he kills me. Instead, you're just expressing concerns with someone you know. That's considered non-testimonial. And you're just talking over here versus trying to create a record over here. I don't like that rule. That's pretty bizarre to me because it relies on this fictional intent of the person because they're not saying what they think about how this is going to be used in the future necessarily. Anyway, flaky neighbor, okay, because non-testimonial, police officer, not okay. So that's what's going on in the Jensen case is the police officer can't talk about the voicemails that Julie Jensen left to him saying, I'm worried he's going to kill me. Here's the things I have as a concern. He can't testify about the letter that he got from her because those are considered testimonial because they were given to a police officer and it could be used against him in the future. But flaky neighbor stuff, that's different. That can come in. So if your blood pressure is starting to go up a little bit and you're starting to say, I knew it, lawyers suck. They come up with these stupid rules that don't make any sense to a normal person. I'm with you on this one. In my opinion, this stuff should be in or it should be out. It shouldn't really matter whether you told your neighbor or the police. And to me, really, if you're telling the police, there's a higher indication of trustworthiness to bring it to court than to say a flaky neighbor down the street. That's how I see it. I understand the logic behind this, but creating this rule where some people can come tell the exact same thing as long as they're not the police that the police got told, does that make any sense? I really don't think it does. So to me, if the Sixth Amendment says keep this stuff out, then it ought to be out. Or if this kind of stuff can come in, then let it in under some certain exceptions. And again, all this is not talking about hearsay rules because that applies second. This is about the Constitution and what can come in or not. So there's a little bit of a kind of a retracement here to say, well, hey, wait a minute. This is kind of bad, right? I mean, because the reason she can't come to court to testify and say this stuff is because he killed her. So the statements that she did make before she was killed, no one's ever going to hear her side of the story as the victim because he's saying, Your Honor, I can't cross-examine her because you murdered her. So there was a little bit of sense in this case, okay, in that a court of appeals said, well, hey, look, it is testimonial, okay, because she told the police officer and we're obliged to essentially see it that way. But there's an exception here called forfeiture by wrongdoing. In other words, if you cause the person to not be available to testify, and therefore you can't cross-examine them, if that's something you did, then you can't take advantage of the Sixth Amendment protection because you're responsible for the person not being available and they should be allowed to come testify. So in a case where you want to murder somebody and then say, well, you can't use their prior statements against me because I killed them, you shouldn't be allowed to do that. That gets down a rabbit hole of, well, then the judge has to kind of decide whether they actually think this person's pretty guilty in order to say, well, you're the one who killed them to let them in. So it gets kind of confusing. But in Wisconsin, they had this expanded doctrine of, look, if you're the one who killed them, as found by the judge outside the presence of the jury and preponderance of the evidence thing, then you can't complain if their prior statements come in because you're the one who caused them to not be able to come to court. But the Supreme Court got involved in this and changed that rule to something that if your blood pressure is already up on lawyers a little bit, take a deep breath and settle it down, because this case, the one that created this rule, is pretty stupid. So there's a case called Giles. It's California, I think. And this guy shot his girlfriend, ex-girlfriend. It's all quite complicated in his grandmother's garage, shot her. And he said it was self-defense. Shot her 6 times. Her hand was up at one point. He was a distance away from her. One shot was on the ground and all that. I mean, come on. So he kills her, right? And he tells in his trial, she said, I'm gonna get you. I'm gonna kill you. She scared him. He closed his eyes, this poor guy, and shot 6 times in self-defense, killing this woman who was unarmed, but he thought she had something to say. So he said things that she said to frighten him. So they called a police officer who had only a little bit before, maybe a few weeks before, had to deal with this woman who said that this guy had attacked her, physically attacked her, and told her, if I catch you with another dude, I'll kill you. Okay. So they called the police officer to rebut this and say, no, wait a minute. Actually, he was the aggressor in this situation, and he had previously threatened her. I mean, this guy's saying what she said. Why can't the police come up and say what she said? And, you know, the idea is, well, they can do that because you're the one who killed her. So if you're going to be blabbing about what you say she said, then other people should be able to say what she said too. Why should the victim who has been murdered be forced to have her final words silenced? So under the forfeiture by wrongdoing situation, you probably could bring that in. Again, I'm not getting the hearsay stuff. This is the Constitution. But the Supreme Court changed that. And they said, no, the mere fact that you might have killed someone and that's why they're not available doesn't remove this protection of confronting your witnesses. Instead, you need to have killed this person because you wanted them to not be able to testify against you. You following me there? So if you just shot this woman because you saw her with another dude and you just took her life for no reason at all, period, just gunned her down in anger, then her statements against you can't come in. But if you gunned her down because you're like, because I don't want you to be able to testify in court against me for whatever, then the Sixth Amendment protection could be removed. That'd be pretty hard to show there, right? So they kind of almost did away with forfeiture by wrongdoing situation. And therefore, they're going to have to create some more exceptions later that I'll talk about. But who else other than a lawyer could come up with the idea of, we have a rule that says if you kill the person and that's why they can't come to court, it means you can't complain about them, you not being able to cross-examine them. Change it to, well, only if you kill them because you didn't want them to be there to be cross-examined. Murdering them because you're a serial killer or you're a domestic violence abuser, a different story there. I mean, you're just killing people. You should still have this protection. But if you did it so they wouldn't testify against you, the protection goes away. Nobody's out there murdering people thinking about things like this, I think, and no normal person would either. But this is the changing rules in the Supreme Court that occurred during this Jensen case that caused his case to spiral from this dude killing his wife in 1998 to being on trial, shown on court TV right now in Kenosha, Wisconsin, because the case has been to appellate courts in Wisconsin many times and in federal court. I'll give you a quick history of that in a minute, just because sometimes you're like, well, does somebody just get one appeal and done? It just does depend, and I'll explain that a little bit. But before we get into the final sad facts of the case at hand here, which is what you don't want to have happen in the Brooks case, which is incessant appeals, some of which are actually successful, let's just cap off where we talked about how this law just got weirder and weirder, right? Well, if you told the flaky neighbor, that's okay, but if you tell the police, that's not okay. But if you tell the police, but the person's the one who killed you, then it is okay. But now we're going to change that and say, well, only if you killed this person so they wouldn't come to court and tell the same thing they were telling the police, then it's, it gets quite confusing, but it also becomes an issue because that narrow construction of forfeiture by wrongdoing changed the game for some of these murder prosecutions where people had made statements to people about who was going to kill them, how it was going to kill them. And in this Jensen case, she was right about who killed her and how the person was going to kill her, and almost essentially the timing of when it was going to happen. So this Jensen case right now, even though it's at trial, the state of Wisconsin has asked the United States Supreme Court to intervene here. And the nature of this is the one at least I'll talk about is domestic violence. And now that you've got this forfeiture by wrongdoing so narrowly construed, they're looking for another way to bring this evidence in. And so remember, the first test is it testimonial or not? So testimonial is you're telling the police officer because you think this could be used against this person later in this crime investigation or prosecution. Non-testimonials for some other reason, like just telling your neighbor because you're scared. But there's also another reason for that called an ongoing emergency. So if you're laying on the ground bleeding out because your friend Rick shot you and the police are there with the ambulance, and you say, Rick shot me, and then the police go looking for Rick and they get him, the court can consider that actually an ongoing emergency, that you are assisting the police to stop an event that's basically in progress. You're in an emergency scenario. So if you were to call the police and say, he's beating me right now, okay, then that could be a situation, or he's forcing antifreeze down my throat right now. That's an ongoing emergency. You're trying to get help. You're trying to stop something. You're not predominantly occupied with testifying against somebody in the future. But if instead you call the police and you say, I'm pretty sure he's going to try to poison me with antifreeze in the future, and then he does do that, they'll say there's no emergency there. Okay, there's no emergency. Your real purpose there was to try to testify against him basically in the future if this does happen. You weren't trying to stop something because the police weren't coming over or whatever. So the state of Wisconsin has asked the Supreme Court to consider a concept of domestic violence, which is the person is in an ongoing relationship where the abuse can occur over a period of time. It's not like your friend coming over and shooting you once in a dramatic event that you're trying to stop, that the abuse can escalate over time. And the person's fear, as they're telling the police about what's going to happen, is based on what has happened and an ongoing pattern of conduct. So they're not predicting an isolated event in the future to testify against this person in the event something even worse happens. It's a form of a cry for help in the ongoing emergency they're already in. And I think there's a reasonable case for that, even in Jensen, if this were an exception like this, because domestic violence can act like that. And not just domestic violence, but a situation where a person can be exposed to an ongoing pattern of criminal abuse. Then I think when they talk to the police, there is a potential that they're trying to stop what to them is an ongoing crisis for them, not just an isolated event. So I think it's a good argument by the state of Wisconsin. And the state of Wisconsin tells the Supreme Court, look, some courts do see it the way we're telling you here. Some courts see it the opposite. And they say, no, if they quit beating you and you call to complain about a future beating, it's just not an ongoing emergency. And they're asking the Supreme Court that, given how these rules are being construed now under the Sixth Amendment, clarify this for cases like domestic violence, where there can be, create this non-testimonial exception for an ongoing crisis being an emergency rather than a discrete event. Now, I think that's very new, so I don't think the Supreme Court has even said whether they'll take the case or not, and I don't know that they will. Most cases they don't take. Where they will take them is usually because there is this split in authority on constitutional questions. So that's why Wisconsin is trying to say, listen, some courts see it this way, some courts see it the other. This is uneven justice. There's a cloud around how this constitutional right should be interpreted. Help us dissolve that, which of course, could help them in this case against Jensen, although it actually is in trial right now. And according to the courts before these final appeals occurred, they had lots of evidence against this guy other than the letter and the voicemails that they can't get in now to use against him. And that certainly was the case. Probably the worst thing is that it's been so long, and I think some of these witnesses are just gone and they're having to replay old boring videotape and stuff. So let's take a quick look at how this Jensen case went off the rails and how you can enter occasionally into an appeal nightmare, which if you're looking for justice, it just doesn't feel like it. This guy killed his wife in 1998. At his preliminary hearing in 2002, he was making challenges to these statements. And the court said, yeah, I'm going to let this letter in, and I'm going to let the oral statements in. In fact, I'll just stop the voicemail, and that's due to the hearsay rules. That's it. The rest of it's coming in. But in 2004, so I guess this case was taking a long time, Jensen asked the court to relook at this because of the Supreme Court's conclusion that testimonial evidence cannot be admitted if the person's unavailable. And the judge said, okay, I'll look at it. Yeah, I agree with that. So now I'm going to throw out the letter and the voicemail to the police because those things are testimonial because they were made to the police. The oral statements to the neighbor and stuff like that, non-testimonial, that can still come in. That's all good, right? Goes to the 2007, it goes to the Wisconsin Supreme Court, who agrees with what the court did below, but then says, look, we have a forfeiture by wrongdoing exception here. So even if it is testimonial, we're still going to let it come in because this is the dude who killed her. So you go back and look at it, court. You do an evidence hearing, and if you find by preponderance of evidence that it's likely that, not with the jury, that this is the guy who killed her, then you can allow this evidence in because he would have been the one who caused the person to not be available for testimony. And so that's how they viewed forfeiture by wrongdoing, that even the letter could come in as long as this is the guy who is responsible for her not being able to come in and saying it herself. 2008, dude gets convicted of first-degree murder. But around that same time, the United States Supreme Court issues its decision in the Giles case, the one I told you about, it was shooting the woman in the garage, and he could say what she said, but she couldn't. The police couldn't say what she said. That case comes out and says, no, forfeiture by wrongdoing only applies if the person murdered the person with the intent to keep them from being able to come to court and testify. Okay, that's not that many murders, right? So it's really narrowed this rule down. So based on this new precedent, Jensen files another appeal and says, listen, the Supreme Court has said that this is all wrong, that this forfeiture by wrongdoing exception is narrowly tailored and you applied it wrong, so let me out, throw out his conviction. The Wisconsin Court of Appeals looked at it and said, that's true, that's correct, that's not how the test needs to be done under the Constitution. But then they looked at it and said, but you know what? There was so much other evidence against you that we'll consider this harmless error and let the conviction stand. So yes, the court was wrong in letting the letter in, but it was harmless error because they were going to find you guilty anyway. So be careful if you say, look at how much evidence there was against Darrell Brooks. No way he can have an appeal work. That's not the standard for appeal. The standard for appeal is whether there was a material error that's reversible. So it can be the case sometimes that so much overwhelming evidence exists that makes it harmless error. You need to be very careful with that. So for example, in this case, he slipped over to federal court with a collateral appeal under a statute that lets you file an appeal if you're being held in state court in violation of federal law, and said, look, the Court of Appeals over here said that it was harmless error for this letter to be let in against me. And in no way it was harmless error because the prosecution was using it all throughout the whole trial. And they said it was super important when they argued for it to be admitted. Now they're claiming that it barely registered in terms of all the evidence. No. So in 2013, the federal district court in Wisconsin said, no, that's not harmless error, that it had a substantial and injurious effect on the trial. The letter was used by the prosecution. And as much as I hate to say it, that's probably the right decision, right? I mean, I don't think you can say that it wasn't used. It's amazing. It's an amazing piece of evidence. So they said, you either got to let him go or you got to start retrying him again, criminal proceedings within 90 days. And if you want to appeal it, I'll stay it at least for that period. So they did appeal it, and the Seventh Circuit Court of Appeals, federal appeals, because you got Wisconsin state courts of appeals over here and you got the federal over here, and their Circuit Court of Appeals said, this is the correct decision. Let's do it. So it goes back down because the state did want to try this guy again because he murdered his wife. And the circuit court did a little tap dance and figured out a way around this whole thing. And he said, well, if that's testimonial evidence under the new rule about he had to have killed her to keep her from testifying, it wouldn't come in. But I'm going to relook at it with other new cases that have come up and say, I think it's non-testimonial. I think I consider that non-testimonial. In the meantime, this dude's going back to district court saying he can't do that. This dude can't do that. This judge can't change this like this. He's not following the writ. And the federal district court said, no, the writ said that they just had to start proceedings against you within 90 days. They did that. And the federal circuit concluded the same thing. We're not going to micromanage the trial. If you don't like how it's going, you appeal to the state court. We just ordered them to retry it again. So he did that too. He went up to the Wisconsin Court of Appeals and said, look, this judge is changing the game here. He's now saying that this evidence, which has previously already been said to be testimonial all the way up and down the chain, he's saying, I looked at it again, I consider it non-testimonial. So in 2020, the Wisconsin Court of Appeals said that the trial court is not at liberty to decide afresh whether those statements were non-testimonial. So the letter and the voicemail are out. Then in 2021, the Wisconsin Supreme Court affirms that. And that's why I said in 2021, the state asked the United States Supreme Court, straight shot from Wisconsin Supreme Court up to the United States Supreme Court, look at what they're doing here. They're not considering this right. This isn't correct. I don't know whether that'll happen or not. In the meantime, this dude is going back to trial without this letter, and I suppose without these voicemails too. So we're going to see whether all this other evidence they say they have is enough to keep this guy in jail or not. They had told the court that there was this mountain of evidence against him outside of the letter and the voicemails, and there certainly is a lot of evidence against him. Hopefully it's enough to finish this thing off once and for all. But the poor letter the woman wrote, she talks about that she would never kill herself. She would not leave her children, her 3 Ds, she said, which were her children's names, and Daddy, Mark, who is the person who killed her. She said, I don't smoke, I don't drink, I only drink like 1 or 2 drinks a week. But he wants me to drink more. She had said that he was following her around with this glass of wine. She doesn't take drugs. She says, I pray I'm wrong and nothing happens, but I'm suspicious of Mark's suspicious behaviors and fear for my early demise, but I would never leave my kids and Mark behind. And the court had said, well, a reasonable person in Julie's position would anticipate a letter addressed to the police and accusing another of murder would be available for use at a later trial, and she intended it to be used to further investigate or aid in prosecution in the event of her death. So thanks, court, for deciding what she intended with that. To me, the ongoing development of this law over the past couple of decades is just disappointing, because they're taking something that's kind of clear in the Constitution, and then it goes down all these various rabbit holes of imagined intents and indicia of reliability and things, and you start getting these various tests that go on, and then that leads to results you don't like. So you start having these exceptions to these tests, like if you killed them, then we'll still let it in. But you don't like how that works. So then you say, well, they had to have killed them on purpose. You don't like how that works. So now you come back over here and you start saying, but if it's domestic violence. Well, to me, laws ought to be as simple and clear as people can make them. And going down all these rabbit holes to get yourself out of one issue from the next, you're creating laws that people wouldn't dream to think of off the top of their heads, could scarcely understand. And as they change and evolve, they're throwing some of these cases into chaos, like this dude being on appeal for almost 20 years to all kinds of courts, just left and right. And yeah, the state pays for some of, maybe all of his state appeals, depending on the posture of the case. There's also a law firm in Wisconsin that is funded by the federal government that can handle appeals for defendants, and they did for this Jensen dude. So he's got help to file these appeals. Now, I'm not saying a defendant shouldn't be able to appeal. I don't mean that at all. As a matter of fact, I could hardly say in this case, because he succeeded on several of his appeals, and his appeals, along with the state's, ought to help clarify the law for the nation on how this stuff works. But it's a pity, though, that even our United States Supreme Court has left some of these things so vague that the conclusions are uncertain, and these cases can't be settled finally one way or the other, because you get a jury verdict and then it gets thrown out because of this rule change. So I don't like that. I think that's one that, when people do say they don't like lawyers, there's a good reason why, because what in the world is all this stuff? And also an extra caution if you're like, well, I'll just represent myself, or I can outsmart all these lawyers and stuff. If you don't know how to find this stuff out, then you're entering a process that you don't even know how the game is going to be played. And I remember when I early practiced, one of the hypotheticals that would be most annoying when people would come up and say the question one way or the other: what happens if my tree falls on my neighbor's property? What happens if my neighbor's tree falls on my property? And there's a free answer and a paid answer. And the free answer is, it depends. And that's how it is so much with the law, that even if you have a clear set of facts, how it gets resolved can get confusing. And as the court's confronted with a wide variety of human behavior, it tries to create fair rules, but those rules themselves sometimes become more confusing. That just make things worse than they otherwise would be. And I think this is a situation like that. Now, I obviously hope, like a lot of people do, that Brooks doesn't find any kind of gap like this in the law that he can run into and say, throw this jury verdict out because this is wrong under this era of law. I think that Judge Darrell tried to do a very good job, and did a very good job, of trying to prevent that kind of error in her case. The clean slate situation of let's hope Brooks' appeal goes up, gets quickly considered and thrown out, is certainly how I want to see it occur, and how I think it will occur. But I wanted to show you another case, concurrent, that's going on in Wisconsin right now, where appeals have gone on for almost 20 years in this case, with complicated issues that change while the people are arguing about them. It's fascinating to see the jurists, the judges in these cases at the higher levels, try and act like what they're saying makes so much sense and it's so clear, when it just isn't. It's changing what was already known. It's creating a test that's largely subjective. Their job isn't easy. They're trying to put into practical application the concepts of the Constitution. I know that's not a perfect science that can be done easily all the time, no matter how people may consider that to be. But here's a case where I think things have gotten murky, and that's unfortunate, and hopefully it gets cleared up. And if the evidence is correct in this case, which I think it is, that this guy murdered his wife, hopefully this trial will end without this disputed evidence, with the same verdict, and this thing will finally be over someday. Thanks, bye.